Land registration in Hong Kong. Well, this is one of the most straightforward lectures we have. Now, question for you to think before we go to the lecture. One owns a watch. He can show ownership of the watch simply by possession, or at the most a receipt of the purchase. How can A show that he is an owner of land? How can other verify that A is the owner of that land? Now, again, just repeat something that we have briefly talked about. In England, we have two systems of proving title to land. One is called registered land and the other is called unregistered land. And in Hong Kong, we are actually following the unregistered system. And in this unregistered system, the vendor has to produce the title deeds, or sometimes called title documents, going back to a good root of title. For this particular lecture, we have to learn some terms of art, some technical terms. Root of title means in Hong Kong it's always the government list, but then for showing good title, then other documents or other transactions may be used. But anyway, the vendor has to produce title documents recording every transaction with the land before the current sale and purchase up to some historical transaction. So the vendor will say, now, this is the pack of title documents I have in relation to the land. Look at yourself. And the purchaser will have to check all these documents to ensure that the current vendor has good title to the property. And in fact, as early as 1925, England has already tried to get rid of this unregistered land system by setting up a registration system, central registration system, under the Land Registration Act 1925. Now, the idea of this system is that the government or the state set up a system of registration. All transactions in relation to the land will be registered in this system, and the state will guarantee this is the correct information. If you find Mr. A is the owner of this property, then it is safe. Just deal with him in relation to the sale and purchase. If there is anything wrong after you purchase a property from Mr. A and Mr. B comes up and said that, well, the property actually belongs to him and he can prove it. Well, if that's the case, then the state, the government, will pay you compensation for such mistake. Now, under this system, therefore, you do not need a lawyer to represent you in the sale and purchase of property. And in England, actually, we have a conveyancing clerk, a special paralegal, in which they will deal with all this easily without big problem. Of course, there are sometimes you still need lawyer because there are some unregisterable interests that cannot be registered, or there may be some equitable interest, which in England we call overriding interest, that may not be truly reflected in the central register, and you have to take steps to ascertain those existence of those interests before you can ask the government to pay you compensation. But in any event, that has simplified the process of conveyancing to a very, very great extent. But it was really out of the expectation of British Parliament that, it is 2021 now, nearly 100 years. But the transaction of land in England, sale and purchase of land in England, was not really as frequent as in Hong Kong. Therefore, the unregistered system still exists, and if they have to, there is new transaction, then they have to move to the registered system. But if there is no transaction, then the old system remains. Now, there are some advantages of this system: finality and certainty. You don't have to investigate the root and the evolution of title under the registered system. And the registration in the central registry represents the most updated record. State guarantee, we already mentioned that. If there is anything wrong in the system, government will pay you compensation. And even if there may be some defect of the title in the history, once it is registered, the title is registered in this central registry, every problem was cured. The registration itself will re-establish the title. And of course, for this registration, you will be given a piece of paper, a parchment, to verify that you have registered. And this is only one piece of paper. But in our system, you have to, keep all those documents, in relation to your property in the past. And you don't have to, as a purchaser, you don't have to go through all the documents, title document produced by the vendor to ascertain whether you are going to purchase a good title. And in fact, we mentioned that already. Before Hong Kong become Hong Kong SAR, the Hong Kong government actually wants to introduce this new system, to Hong Kong. But there was too many bills trying to go through the Legislative Council then, so this bill was not passed. But the bill was somehow revived in later Legislative Council after Hong Kong became SAR, and in 2004 the bill was passed duly by the Legislative Council, become Land Titles Ordinance, Cap 585. But our nightmare still remains, because under this section 1.2, it is said that ordinance shall come into operation on a day to be appointed by the Secretary for Development. And so far, no Secretary for Development after Hong Kong become Hong Kong SAR or after 2004 has appointed a day for the operation of this land title ordinance. So we are still stuck with the old system. For current conveyancing lawyers, this is good news, because we can still have a money-generating machine. Once we believe that once the land register title bill take effect, then once any transaction took place, this is the last chance for lawyers to get money for that particular transaction. Because when it is registered in central registry, everything should be settled. And they can just follow the registered land system as in England. And now we do have a registration system called under the Land Registration Ordinance, but the registration is completely different thing. This system provides a record of transaction, any sale and purchase, creating lists, creating legal charge, etc., affecting the land. And the system is mainly, one of the most important function of the system is to modify the doctrine of notice. Remember the equity Starling, equity will not intervene when there is a bona fide purchaser for valuable consideration and without notice. That particular maxim somehow modified by this land registration ordinance. Basically, this ordinance changed the requirement for notice. Now, under the land registration ordinance, a bona fide purchaser, now bona fide purchaser is always necessary because we only protect real transaction, is subject to a registered interest. Any legal interest, equitable interest, which is registered under land registration ordinance, would be binding on any subsequent purchaser. Even this purchaser has no notice of their existence. Of course, once they conduct a land search, they would discover such registered interest. Conversely, a bona fide purchaser for value takes priority over an unregistered but registrable interest, even though he has notice of such interest. So, if it is a registrable interest, but you fail to register it, then even the bona fide purchaser knows that such interest exists. For example, an equitable interest exists. He has no worry. He can just go ahead and deal with the property with the legal estate holder. That would be adequate, because under land registration ordinance, if you have a registrable interest and you fail to register it, you have no effect. And just give you some history about the development of this land registration ordinance. First of all, in fact, after the British Navy landed on Hong Kong Island, 1 or 2 months later, they already conduct auction for land to be sold in Hong Kong, 1941. And I've told you already, at that time Hong Kong was so primitive, so most of the officials of Hong Kong government actually live in Macau. And at that time, everything is so primitive, no one was serious about what kind of legal interest is going to be created by the British Crown selling a piece of land to people. And they just use a notebook to record, there was a sale of property. And this particular land officer adopt the present system of registration. He just register as a record of any transaction affecting a piece of land. And such record show the priority of any claim in relation to the property. And later on, the land officer was abolished, replaced by a land and roads inspector, but he did not change the registration system. And all this could be seen as the predecessor of the land registry today. And ultimately, in 1844, just 4 years after Hong Kong became the colony of England, we have this Ordinance 3 of 1844 enact, And in fact, that is the first version of land registration ordinance. And it is, in fact, one of the oldest surviving piece of legislation in Hong Kong. And it has only a very minor amendments made, since it was enacted in 1844. And if you have studied English, you should know that 1844, that was a time in England called the Victorian period, because Queen Victoria was the queen. And for English, we have a term called Victorian English, which is a famous English style. And the style is 悠長悠長, long and repetitive. Look at the ordinance itself. It has not been amended, and you can see this is the characteristic of Victorian English. Okay, section 2. It defines what is a registrable interest. Land registry shall be a public office for the registration of these conveyances and other instruments in writing. So the first thing you have to note is in writing. Why? We say legal estate has to be created by deed, equitable interest has to be created in writing and signed by both parties, because they're corresponding to this section. They become registrable interest. And judgment and all these conveyance and other instrument in writing, and all judgment by which these conveyance and other instrument in writing and judgment and any parcel. So they're talking about the same thing. Any parcel of ground tenement premises in Hong Kong, ground tenement premises mean the same thing, may be affected. So if there is any written document, in short, actually what it means is any written document, including a judgment by court in writing, that would affect the interest or right of a land, may be entered and registered in the said office is land registry, in the prescribed manner. In other words, any transaction which is represented by some writing and also judgment may be entered and registered. They are registrable interest. May be actually means must, in order to earn priority. And for the purpose of this ordinance, judgment include judgment and order of the court of first instance and district court and the lands tribunal. So only judgment from this court would be registrable interest. Of course, court of appeal, court of final appeal would be included as the appellant court for the court of first instance, or district court or land tribunal. Now, so for the concept of registrable interest, what are registrable interests? Any interest created in writing, and judgment in writing. Section 3. Subject to this ordinance, all such deeds, conveyances, and other instruments in writing judgment, repeat, make, execute, or obtained and register in pursuance hereof. If these interests are registered, then this interest shall have priority one over the other, according to the priority of the respective days of registration. This is the key issue in relation or under Section 3. Now, once you have registrable interest, they are registered in the land registry, then their priority would depend on the date of registration. Now, if it is that straightforward, then everything is much, much easier. The problem is we come to later what are the problems. But look at the subsection 2. These conveyance and other instrument in writing judgment which are not registered. Now this is very important. You must register in order to enjoy priority. If you are not registered, then what is the consequence? Shall, as against any subsequent bona fide purchaser or mortgagee for valuable consideration of the same land, parcel of ground, tenement, or premises, be absolutely null and void to all intents and purposes. Now, this is important because once you have a registrable interest, you may register. But if you do not register it, then it will become null and void for a bona fide purchaser or mortgagee for valuable consideration. So it is a statutory amendment of equity Starling. Equity Starling said, equity would not intervene when there is a bona fide purchaser, for valuable consideration and without notice. Now they are taking off the requirement of notice. You have to register, otherwise your interest will not be protected. Provided that nothing herein contained shall extend to a bona fide list as rec rent for any term not exceeding 3 years. Now this is also the exception for oral lease. You can have an oral lease, even though in general you must have a deed or an agreement in writing. But as long as the term of that tenancy is less than 3 years, not exceeding 3 years, at rec rent, the concept of rec rent is the same as best obtainable market rent. So, in fact, it is the old term. It is a Victorian English. Now we do not use the word rec anymore in our daily usage, but the meaning is the same as Section 3 of CPO. Now, Section 2 defines what is registrable interest. Section 3 tells you if you register, you will enjoy priority. If you fail to register, your interest will have no effect to a bona fide purchaser or mortgagee. Section 4, no notice, actual, constructive of any prior unregistered deed, conveyance, and other instrument in writing or judgment shall affect the priority of such instrument as is duly registered. Now, this is one step further from subsection 2 of section 3. Subsection 2 of section 3 said, any interest registrable but not registered would have no effect. And section 4 actually is afraid, the Legislative Council was afraid that lawyer would still argue, what about equitable darling? Don't worry, because section 4 make it clear, notice, actual or constructive are irrelevant once you fail to register. And all these conveyance and other instruments in writing judgment which are duly registered within the respective time next mentioned, that is to say, all these conveyance and other instruments in writing which are registered within 1 month after the time of execution thereof respectively. Now, register, when to register. This is when to register. You have to register within a month of the date of that document. If you execute a list on the 1st of October 2021, then you have to register before the 1st of November in order to enjoy the protection under Section 5. And all judgments which are not registered within 1 month after the entering up or recognized recording thereof shall severally be in like manner entitled to priority and shall take effect respectively by relation to the dates thereof. Now this is the tricky part. The registration period is 1 month from the date of the instrument. So if you create it on the 1st of October, you are entitled to register it latest 31st of October. But for counting priority, it is not the date you register, but the date of the instrument. So that if you can register the document within this 1 month, for this registration to take effect, it is the date of the document. Now, again, words are more difficult to understand than by a drawing. Say, for example, we have a vendor. Okay? He executes a SMP, sales and purchase agreement, with purchaser 1 on 1st October 2021. Okay? And this guy is a cheater. Subsequently, he exercised another SMP agreement of the same land to P2 on, say, 16th of October 2021. Now, because P1 has 1 month to register his document, when P2 entered into this SMP with we, he did not find the SMP with P1 in the land registry upon a land search. So he thought it was safe to enter into this agreement with we. But on the 31st of October, P1 registered his sale and purchase agreement. Then, under Section 5, shall take effect by relation to the date of the document. And the registration is deemed to be on the 1st of October. So that, in terms of priority, this first sale and purchase agreement take priority over P2 sale and purchase agreement. So, at the end of the day, P2 may have to lose money to V. Now, of course, in this case, if he can locate V, he can sue him for, breach of agreement. But basically, that is the tricky point on Section 5. Anyone is given a month to register a registrable interest. But if you can meet this deadline, register the registrable interest within 1 month, the effective date for registration is deemed to be the date of the document. Okay? But, say for example, if P1 did not or failed to register within 1 month, say he registered on the 2nd of November, then too bad. Even though the agreement date 1st of October, because he registered on the 2nd of November, which is outside the protection of Section 5, then the day of registration is to be the actual day of registration, and he will lose priority to the sale and purchase agreement between P2 and V. So it is important to register within 1 month. So now understand that all these original language of these three sections are difficult to understand. So I'll give you a summary here. Pursuant to Section 2, all these conveyance and other instruments in writing, including writs and judgment that may affect the interest of land, are registrable. So everything in writing are registrable. Oral interests are not registrable. Operation of law is not registrable. Resulting trust. I purchase a property in my friend's name. I am the equitable owner of that property, and my friend is the legal owner of the property. This is not registrable because the effect is taken by operation of law. Section 3 provides that registration of interest give priority as against subsequent bona fide purchase of mortgagee for valuable consideration, whereas any unregistered registrable interests are void. Now you must be registrable. Resulting trust is not registrable. Therefore, even there was no such registration of the resulting trust, of the interest represented by the resulting trust, it would not be void against subsequent purchaser. And that is why in Wong Chim Ying's case, Mrs. Shang lose the property. And except that a bona fide written list at ran and of a term less than 3 years, this is a particular legal interest that is not required to be registered, even it is in writing. Because Section 3.2 expressly excludes it. Go back to Section 3.2. Provided that nothing herein contained shall extend to bona fide list at rent for any term not exceeding 3 years. So even though it is in writing, as long as it is not exceeding 3 years at marketable rent, it is not required to be registered. Section 4 provides that where there is an unregistered but registrable interest, even if the subsequent purchaser or mortgagee has actual or constructive notice of such interest, such notice does not give priority in favor of the unregistered interest, and the subsequent purchaser or mortgagee takes the property free. And Section 5 provides that a registrable interest must be registered within 1 month in order to obtain priority. As long as the interest is duly registered within 1 month, it is deemed that the date of registration for counting priority is the date of the interest was created, but not the actual date the interest was registered. And under Section 5A, now this is a special registrable interest that may affect land. Registration of a charging order. You should know what is a charging order now. It's basically arising from a judgment debt that a party failed to pay a judgment, and then the holder of that judgment can go to court and ask the court to make a charging order for that person to register against the title real property. Now, if you are talking about charging order and lis pendens is actually referring to the writ. Lit meaning litigation, pending means pending litigation. So any writ, any originating someone, they are in writing, so they have to be registered. But their registration are different from Section 5, from other instruments. Their priority takes effect from the day following the actual day of registration. So these two, charging order and lis pendens, are the exception to Section 5. For Section 5, if you're talking about sale and purchase agreement, an assignment, a judgment, etc., as long as they are registered within a month, the date of registration would be the date of the instrument. But for charging order and lis pendens, it only takes effect, priority only takes effect from the date following the actual date of registration. So this is not really that complicated. I think it's rather straightforward. Okay, look at this question. A sold a flag to B and subsequently sold the same flag to C, just like what happened here. B solicitor forgot to register assignment for B within a month, and B solicitor tried to register the assignment 2 months later. He finds that C already registered an assignment of flag from A. Day of completion was 2 weeks from the day of completion of the transaction between A and B, and Y is B. It's exactly what I have already explained here. Too bad, B right would be subject to C's interest, even though they actually have the transaction earlier than the transaction between A and C. You will say, hey, Tommy Ho, you are talking about jokes. No one would be foolish enough to fail to register an assignment. It's not invented by me. And there is an actual case. This action for Fast Forward Limited arose from competing claims of 2 purchasers of a roof on an industrial building. The second purchaser, which is the plaintiff in the present case, acquired the main roof of that building in 1988 under an agreement for sale and purchase and an assignment. Call it 1988 assignment, okay? Because only when you get the assignment from the vendor, you would not have the title of the property. And the assigner was this Sui Ying company. And this purchaser registered both the assignment and the agreement. And he tried to get possession of the main roof against both descent. I skipped this first purchaser. First purchaser acquired the main roof in 1980 under the assignment, called it 1970 assignment, from Sui Ying. Now, of course, it is an assignment, it's a deed, it is registrable, but Solicitor for Wong did not register this assignment for Wong. And Wong believed that he got the assignment, he paid the owner, so he became the landlord, and he rent the roof to second defendant. And at the time of this litigation, the second defendant was occupying the main roof as the tenant. And then we already introduced this particular case. And then the plaintiff, after he registered his assignment, he asked the defendant, the second defendant actually, who were occupying the main roof, to vacate the main roof, saying that, well, I'm the landlord now, please vacate the roof. And this guy said, no, I have this list with the landlord, this is my list. So they went to court, and the court looked at this documents. Yes, there was this 1970 assignment, and there was a valid tenancy agreement between first and second defendant, but they were not registered. Whereas the 1988 assignment and sale and purchase agreement were registered. Plaintiff said, his document has been registered under the Land Registration Ordinance. Therefore, the interests of the defendant were overreached. Remember what Section 4 said, or Section 3 said. First, unregisterable but unregistered interests are null and void against bona fide purchaser or mortgagee with valuable consideration. So they're null and void against plaintiff. And he said, well, they know. Second defendant said, they know. I am occupying the roof. Section 4 said, any notice, real, actual notice or constructive notice of the existing of such unregistered but registerable interest would have no effect. Court just held as the law provides, all registerable but unregistered instrument would be overreached by a subsequent registered instrument under Section 3.1, whether or not the parties to subsequent registered instrument have notice of the prior registerable but unregistered interest, Section 4. And even if the subsequent registered instrument was expressly made subject to any prior registerable but unregistered instrument, all registerable but unregistered instrument were null and void as against any subsequent bona fide purchaser for value, Section 3, subsection 2. So, first defendant's right to use the service of main roof, it is registerable, but not registered. Unregistered interest which is acquired full wrong was null and void as against the plaintiff, who is a subsequent bona fide purchaser under the 1988 assignment, and the assignment was duly registered. So, in this case, plaintiff claims against both defendant for possession. So, second defendant has to vacate, means profit. Now, remember this term? Said if you cancel a lease but want to charge your previous tenant for occupying your property, you do not ask for rent, you ask for means profit. Means profit is the fees for occupying another person's land, which is not under any legal right. And cost, of course, litigation cost for that action. So in reality, there is really such calling foolish or ignorant person who fail to register their title document. But this is a very good case to demonstrate the operation of this frill section 2, 3, and 4. Now, it is important to note that the registration under the ordinance only confer priority, who is subject to who, but not the validity of the instrument. So, for example, if you register an assignment, duly register, it does not mean that the assignment itself is proper there may be some problem with the assignment that the government would not care and would not compensate you for any loss if you rely on the registration of that assignment as an indication that the assignment was properly executed. Registration of lis pendens, remember, pending action, writ or originating summons, has created some difficulty in the present system of registration. Under Section 2, to be registrable, pending action must be affecting the interest in land. Then, what about an action in which purchaser claims the refund of the deposit paid under a sale and purchase agreement of the real property? You know, the purchaser said, the vendor does not have a good title, therefore I want to cancel the contract, I want to claim my deposit back. So this claim does not affect the interest in land. Can we therefore say this writ is not registrable? Now, strictly speaking, it should not be registrable. But it has been held by court that, actually that was the common law tradition. In a case like that, the purchaser may still be entitled to register the lis pendens of the action against the title of the property, not because the action affects the land, but because of an equitable lien. Lien is a term that you have to learn in land law. It means it's a right to keep the property on the property for the security of the return of the deposit paid. So even though the purchaser is not asking for specific performance, just to get the return of the deposit and damages, which has nothing to do with the land, such action could still be registered against the title of the property, by virtue of this so-called equitable lien. Now, as I said, lis refer to litigation. If there is a dispute in relation to the interest in land, but that dispute has been admitted, by the defendant. The plaintiff claims he has a right. Defendant says, okay, yeah, you have a right. Now, if that's the case, then there is no more litigation in relation to the interest in land. And then under Section 2, that particular writ is not registrable. And in fact, there again, we have a case to illustrate this principle. In this case, one part of the dispute is the easement that the plaintiff is relying on, and the defendant admitted that there was such an easement. Now, once this was admitted by the defendant then went to court and asked the court to vacate the registration of the lis pendens on the ground that the litigation now has nothing to do with the interest in the land. And in fact, the court agreed with such argument, since the interest in land no longer in litigation, and the lis pendens is not registrable and has to be vacated. So that's about land registration. It is not that difficult, rather straightforward. But this is a prelude, for our more difficult subject matter, for the law for conveyancing. So we come to the conveyancing part of our lectures. And we are only touching on the surface of conveyancing, because the law about conveyancing could be very complicated, particularly when the parties were disputing whether, parties referring to a vendor, purchaser, was disputing the good title of the property. Now, conveyancing, what does this word mean? It is a process of transfer of ownership of land from one person to another person. That is the meaning of conveyancing. You transfer your title to a property to another person. If it is a purchaser, you sell the property to him. You then transfer your ownership of the land to him. Or if you want to give your land to your daughter, then you can also transfer the title of the property to your daughter as a gift. Now, there are different ways of transferring the ownership of land. Gift, for example, or sometimes a will. The father died and said, the property I own, of course, then the time he died, it becomes the estate of that deceased. And in the will, he said the property would go to my surviving widow. Then the property would be transferred to the widow under the will. And of course, the most common reason for transfer of ownership is sale and purchase, or sometimes by operation of law. Now, no matter we are talking about a gift or a sale, the land is transferred by deed of assignment. In fact, this is also transferred by sale and purchase is the focus for our syllabus. Now, it must be by a deed of assignment, because under Section 4, remember, if you want to create or dispose of a legal estate, you have to do it by deed. Therefore, when you transfer the title of property to the subsequent holder, then unless you do not want to transfer the legal estate, then you must have a deed. And this is, in fact, the most common method of conveyancing in Hong Kong. Now, if a land is transferred under a will, usually the transfer is carried out by a document called an assent. And usually, because the will would be executed by executor, this executor would assent, the technical term is the executor assents the land to the beneficiary under a probate. And if the transfer is effected by law, for example, principle of survivorship, in a joint tenant situation, one joint tenant pass away, there is no formal requirement, in cases like that, just like the certificate of compliance for the proof of the existence of the legal list. I mean the government list. If you want to show that one of the joint tenants passed away, therefore that deceased joint tenant's interest in the property has been passed to the surviving joint tenant, then you need the death certificate of the deceased as evidence. But it is not because of this death certificate that the right of the deceased joint tenant is passed to the surviving joint tenant, because it is by way of operation of law. And we will focus on the transfer of land by sale and purchase. Of course. Now, of course, sale and purchase is misleading. Remember, because in Hong Kong there is actually no sale and purchase of land. It is only granting of lease from the government to the lessee, and then the lessee transfer the lease to a subsequent lessee. So first thing is so-called sale of land by the government. And in fact, it is granting of lease by the government. Most common way is public auction, and other way, including exchange. If you already possess a piece of land and you can surrender that piece of land in exchange for another piece of land by the government, there is what we call by exchange, granting a lease by exchange. And no matter the government grants you a new lease or exchange a lease to you, the government will impose certain conditions for the lessee to comply with. Remember, under Section 14 of CPO, once all such conditions are fully complied, a government lease is deemed to have been issued. So, since government no longer issue the physical copy of the government list, then the certificate of compliance issued by the Lands Department becomes the evidence. Now, that is the sale between the government and the developer. That is common, but in terms of number, the more common way of sale and purchase of land in Hong Kong is the sale and purchase between individuals, which is usually described as secondary sale. Primary sale is from the government to the first lessee, to the developer. So, for example, developer A purchased a piece of land from public auction and then sold the land to developer B, and the first sale and purchase from the government is called primary sale, and this sale by developer A to developer B is called secondary sale. And of course, if we are talking about selling and purchasing of a piece of land, then of course both parties would be represented by the solicitor before any contract is signed. Now, the third type of common sale and purchase would be when a developer, he has fully developed a piece of land into different multi-story building. They can sell the units or the entire development. That if we're talking about third type, we're talking about developer selling the finished units to individual purchaser. And in this case, they are also known as secondary sale. And it's not different from selling the complete development from one developer to another developer. Now, in Hong Kong, again, Hong Kong is a very interesting place in terms of land transactions. And we have a concept called 賣樓花, selling of unfinished unit of a multi-story building. And nowadays in Hong Kong, you can only sell unfinished unit of a multi-story building by a so-called consent scheme and non-consent scheme. And in chapter 10, we'll talk a little bit more in relation to these two schemes. Basically, consent scheme is applicable if the land on which the building erected is newly sold by the government. The government put a piece of land on auction, developer A, Changgang, for example, purchased that piece of property, and before the development is finished, they sell the so-called, building flower, unfinished units to individual purchaser. Then they have to follow the consent scheme, and they have to make some application, and they have to satisfy the lands department that all they are financially powerful enough to finish or to complete the development before they would be allowed to sell the unfinished unit. And what about a developer who has purchased all the equal and divided share of an old building and want to redevelop that particular piece of land? Now, at this in this situation, the consent scheme would not be applied, and they have to do it in a so-called non-consent scheme. As I said, we'll go a little bit deeper into these two schemes in the last lecture. And after individual purchaser has purchased a unit newly developed, he may sell it to subsequent purchaser. This is what we call the pirate sale and purchase of second-hand units of multi-story building between individuals. Now, and in fact, this is the most important type of sale and purchase for us in this syllabus, because the system is different from other kinds of sale and purchase. In this particular type of sale and purchase of a second-hand units, the vendor and purchaser would enter into what we call a preliminary agreement, or some kind of provisional agreement, drafted by an estate agent or agency. And in Hong Kong, the interesting thing is, in this preliminary agreement, there are three parties, a tri-party agreement, not just between the vendor and purchaser, but the estate agent is also one of the party. Now, this agreement would have signed before the vendor or purchaser instruct any solicitor to represent them. And the agreement itself is already binding, So this is a very peculiar kind of practice in Hong Kong. Of course, in the previous lecture, we talked about mortgagee sale. Mortgagee sale is also a common type of sale and purchase. It could be sale of a piece of land or unit in a multi-story building, and when the mortgagor, the borrower, is in default of mortgage repayment. And for this particular sale and purchase, again, there is different procedure. Mortgagee may have to apply for a power of sale at the court. Now, so as we said, we are talking about sale and purchase of real property, second-hand real property in Hong Kong. That is the focus for our syllabus. Now, if you want to purchase a car, even as valuable as a car, the process is quite straightforward. You just go to car agents, and then sign a document, and if the car is available, you can pick up your car in a very short period of time. But a normal sale and purchase of land between private individuals in Hong Kong is divided into 3 stages. And the entire period for these 3 stages to go through is at least 1 month. This normal situation, at least 1 month. In most cases, more than 1 month. And these 3 stages, I call it contractual stage. From contract to completion. Completion means the completion of the sale and purchase. And then, the actual completion. And each of this stage would involve complicated law. Why? Why we have to do that? Why we have to divide this sale and purchase of land in these 3 stages? The reason that we have to divide the sale and purchase of land in the stages has to do with our complicated concept of ownership of land. Now you have learned so many lectures now. You should know the concept of ownership is complicated in relation to real property. And there is a real danger that if you want to purchase a property with a vendor, and this vendor actually does not have good title to the property, you may end up either what the usual description is buying a lawsuit. Someone is going to sue you. Or buying an empty title, just like Wang Chun-ying and Chen Kam-wing pay several millions dollars for nothing. Or sometimes when you purchase property, you have to make a huge amount of money for making compensation in a lawsuit, or the government sue you for failing to comply with certain orders. All this could happen in the sale purchase of real property in Hong Kong. Therefore, the most important concept to learn in relation to conveyancing is this concept of good title. Now, in our legal expression, in our legal usage, we say a vendor, if you are selling a property, you are a vendor. A vendor has a duty to show, or sometimes we use the word prove, but more often we use the word show. To show and to give. There are 2 stages. To show and to give good titles to the purchaser in the sale and purchase of land. And this duty to show good title, to prove that you have good title, has to be fulfilled before completion, before the date vendor execute the assignment, purchaser pay the balance of the purchasing price. And when you give good title, it is on the moment completion takes place. And how can you show and prove good title? Under our unregistered system, the Hong Kong style of conveyancing, the vendor shows good title by the production of all documents relating to his title. So that's why in the previous lecture about registration, we say you have to keep a huge bundle of documents. If the land, say for example, Tai Kwu Sing, you should have a very thick, bundle of the title documents, because that list was executed in 1840 something. Otherwise you won't have 999 years. And you have to keep all these documents. And when you sell the property, you have first of all to give the purchaser all the document for the purchasers to inspect and examine. And the purchaser, if he has or he detect any problem with the document, he can ask you question. We call that raising requisition, to raise requisition. And your duty to give good title, to show good title, include to answer all the requisition made by the purchaser satisfactorily. So there are actually two things you have to do. First of all, you have to produce document. If you do not have some document which is required under law, then normally, unless the purchaser accepts the absence of such document, otherwise, that's the end of the transaction because you fail to show good title. Second stage is the purchaser's solicitor look at your document, just like the example I gave about Heng Hon Do. They look at the government list. Well, the land is restricted for the erection of villa, but it is a 10-story building. Well, can you explain to me why you got this permission to erect a 10-story building? Do you have a formal approval from government, for example? You have to answer. You say, oh, don't worry. Actually, we have made an application. Now, this is the document to prove. Oh, you satisfactorily answer the question. But in most cases, that kind of thing could not be answered. And then you fail to answer satisfactorily the requisition. You fail to show good title, and that's the end of the transaction. Unless, of course, in Hong Kong, we have many unless, because people are crazy about real property. Oh, okay, yeah, just sell it to me, I don't care. And that's why we have so many crazy title problem discovered only in 1997, when there was a huge slump of the property market, when everyone wanted to avoid the contract. In the past, even though the purchaser solicitor may have noticed the problem, but when he tells the purchaser, well, there is some potential problem with your title, the usual question the purchaser asks, well, would that affect my, the chance for selling this property in future? Yes, there's a chance. Depends on whether the solicitor of the future purchaser detect this problem. Oh, in that case, don't worry, I will accept it. Now, that is the Hong Kong style of sale and purchase of real property, and therefore, in many cases, it creates a lot of job opportunities for us. Now, proving. Now, that is the way the court say, prove it as a matter of evidence. That is to say, just show me the documents. If you have any problem with the document, I give you evidence to explain. You say, I do not have this approval. Oh, I show you the letter from the lands department, show you this approval from the building authority, etc. These are the evidence to prove your good title. And this is important because we learn, unlike the land title ordinance, which will give us some safeguard. The current registration system only gives you priority, but does not give you any assurance as to the validity of individual title documents. Therefore, purchaser has to ensure that you are purchasing a property with good title. Otherwise, at the end of the day, it is you who suffer. Now, the current practice in Hong Kong is that even after the execution of the sale purchase agreement, not just the preliminary agreement, but also the formal agreement prepared by the solicitor, the duty for the vendor to show good title just begin. Either party, just like a common contract, if you are in breach of a condition or serious breach of an intermediate term, then the other party is entitled to terminate your agreement. So this contract law provision, legal principle, would also apply. So even if you have signed the sale and purchase agreement, that is not the end of the matter. Party may still rescind the agreement without having to go to court for relief. So unlike purchasing an iPhone in a shop, proper shop of course I'm talking about, in which cases if you go to say Apple, you get your iPhone and can usually start to use it without worrying about whether you have a good title to the iPhone. But in the purchase of land, even if the vendor formally assign the land to you, give you a good looking piece of document called the assignment. But if the vendor himself does not have good title, what you get is also a bad or even a void title. And land is so expensive, so precious in Hong Kong. All purchaser wants to ensure that he get a good title. And therefore we take time to go through this sale and purchase process. Okay, we'll just stop here and